Call the first case on this morning's docket, case number 116098, State of Kansas v. Clyde Lacey Newton, Jr.
May it please the court. Mr. Chief Justice, and may it please the court, Kai Mann on behalf of the appellant, Mr. Clyde Newton. May I please reserve 3 minutes for a rebuttal?
3 minutes is granted.
Thank you, Your Honor. On March 24th, 2008, Mr. Newton pled guilty to 1 count of attempted rape. At sentencing, the district court found Mr. Newton's criminal history score to be that of a B, due in part to a 1977 California robbery conviction. It then granted Mr. Newton a durational departure to 165 months incarceration. On June 30th, 2014, Mr. Newton filed a pro se motion to correct an illegal sentence, arguing that his pre-1993 convictions should have been scored as non-person felonies pursuant to State v. Murdoch. Following the district court's denial of his motion, Mr. Newton timely appealed. On appeal, Mr. Newton argued that his criminal history score of B is incorrect, as the elements of California robbery are broader than the Kansas crime of robbery and could not be scored as a person felony. The Court of Appeals disagreed, finding that the broader elements of the California robbery statute did not matter, as they only needed to be similar in nature and cover a similar type of criminal conduct to be comparable to a Kansas robbery statute. Mr. Newton timely appealed this court for review, which was granted on June 4, 2018. Now, in the time between Mr. Newton's initial brief to the Court of Appeals and the granting of his petition for review, 2 significant events occurred. First, on May 18, 2017, the legislature amended the illegal sentence statute, KSA 223504, to include a provision stating that a sentence is not an illegal sentence due to a change in the law after the sentence was announced. Secondly, on March 9, 2018, this court released its opinions in State v. Wetridge, State v. Buell, and State v. Moore, announcing that for an out-of-state conviction to be comparable, it must have elements that are identical to or narrower than the Kansas crime. This court ordered the parties to show cause why this court should not vacate Mr. Newton's sentence and remand pursuant to Wetridge. The state responded that Wetridge was a change in the law pursuant to the amended KSA 223504 and that the amended statute should be applied retroactively to Mr. Newton. This court then allowed for supplemental briefing and set the case for argument, which brings us to today. Now, I think at this point it's most helpful to start out with this court's decision in Wetridge, Buell, and Moore, noting that those were determined on a statutory basis. Mr. Newton allegedly committed his crime on November 3, 2007. Therefore, the 2000 version of the Kansas statutes apply to him. And relevant part, KSA 2007-2147-11E, states that if a crime is a felony in another state, it will be counted as a felony in Kansas. The state of Kansas shall classify the crime as person or non-person. But then, in designating a crime as person or non-person, comparable offenses shall be referred to. This language is very similar to the language in the current KSA 216811E3, the descendant of KSA 2007-2147-11E, and states in relevant part, in designating a crime as a person or non-person, comparable offenses under the Kansas Criminal Code effect on the date of the current crime and conviction was committed shall be referred to. Now, in Wetridge, this court made it abundantly clear that it was interpreting the term comparable as a matter of statutory interpretation, and identified that term to require identical or narrower to be the rule.
And was that the first case that purported to construe or interpret comparable offenses in that context?
In the particular context of subsection E, yes. Because Dickey 1 and Dickey 2 was dealing with this specific burglary.
That was my understanding as well, is that was the first time this court had purported to interpret comparable offenses in this fact scenario.
Yes. And also of an important note, and more, also in Buell, this court noted that it was not simply interpreting the comparable offense in the 2017 and 2018 versions of KSA 216811, but it also noted that it was interpreting the term comparable offense to the ancestors of that particular statute, which of a particular note, Mr. Newton is in a very similar procedural posture as Mr. Moore, as they both filed their motions to correct illegal sentences in 2014, many years after their original convictions were handed down and became final. And so, as a matter of pure statutory interpretation, this court has already said that the comparable offense, as determined in Wettrich, meant identical or narrower back at the time and when Mr. Moore and in which Mr. Newton was sentenced, and therefore this should be applied to him just as a matter of statutory interpretation. And this goes to the fact that Wettrich is not a change in the law. First, as a matter of simple separation of powers, only the legislature has the power to change a statute. Secondly, as stated...
Well, let me stop you
Yeah.
there. Only the legislature has the power to change what's written in the statute books.
Yes.
But if this court were to interpret a statute one way and then a few years later interpret the same statute a different way, wouldn't that be a change in the law?
Not necessarily. I think it depends on the nature of the opinion and the nature of the question. I think a good example of what might have been a change in the law was this case, or this court's case in Spencer Gifts, in which this court explicitly looked to Bolliker and overruled the interpretation of Bolliker, granted based on his change in the statute, but changed to understand that statute. Here, we have no overruling of prior cases.
That's why I asked about whether
Yeah.
Wettrich was the first case to interpret the statute.
Yes, I mean there was some.
There was no overruling of some prior
No,
interpretation in
there was
Wettrich.
not. There was not. If anything, it was just simply a clarification of prior case law. And furthermore, our United States Supreme Court has noted that a judicial construction of a statute is an author's statement of what the statute meant before, as well as after the decision giving rise to that construction. And further, in the same case, stated that this principle that statutes operate only prospectively, while judicial decisions operate retrospectively, is familiar to every law student. A foundational matter that is just simple.
How do you get around? I mean, the problem I have with your argument is that it's awfully clear when you look at the legislative history that when they were across the street passing this law, they were pointing across 10th Street over to here. I mean, they were clearly intending to take care of situations like Dickey and all that. They weren't sitting around going, well, if we change the statute, that means. So I just don't see where legislative intent can possibly get you to where you want to be with that argument.
With the argument that Wettrich was not a change in the law?
Yes.
Okay. Just as a counterpoint to that, I would note that the Court of Appeals, in the cases that I've cited in my supplemental brief, as well as my 609 letter, have routinely found Wettrich should not be a change of the law. And in fact, those decisions involve 13 out of the 14 judges of the Court of Appeals. And furthermore,
But none of those have addressed none of those were looking at the legislative history and saying what was intended by that statutory change. They try to analyze whether Wettrich was just an interpretation or something like that. And I get that analytical path, but I'm still stuck with what did those guys intend over there when they did this?
Right.
Do you find something in the legislative history that would tell us that they intended to focus only on their particular revision to a statute as opposed to some crazy thing this court was doing?
The only thing I saw was the testimony of Ms. Chalmers when she was testifying in support of the bill, in which she mentioned the recent United States Supreme Court case law, I think thinking Dickey 1 was a constitutional decision, and about how this change was needed to stem the tide of these illegal sentence motions that have been litigated, which I think poses another problem, because then this makes the revision to the statute plainly substantive and not procedural, and therefore inapplicable to be applied retroactively, which I think is also evidenced by the fact that there is no retroactivity provision within the change of 223504 allowing that statute to run retroactively.
But Counselor, can't that cut both ways? You have the AG over there saying, we have this decision that's creating havoc, you gotta take care of it, get rid of it, and we don't want the consequences of that decision. And they've done that before. They did that with the felony murder and the lesser included, and the legislature responded by in their amendment says that this establishes a procedural rule for the conduct of criminal prosecutions shall be construed and applied retroactively. They did that with the criminal history classification so that they could overrule the effect of one of our decisions. And same thing said, specifically stated that as procedural in nature shall be construed and applied retroactively. The hard 50, they called a special session,
Right.
and made sure that they knocked off so no other hard 50s could be overturned that way, and said shall be construed and applied retroactively to all crimes committed prior to the effective date of this act. And here they heard Ms. Chalmers say the sky's falling because of Dickey, but they didn't take the step of specifically stating what they know how to state, that this is procedural and applies retroactive. So how do we know that it wasn't their intent to apply it prospectively? Okay, we'll solve the problem for you, AG, but it's solved the problem from here forward. I mean, that makes as much sense as to say they intended it retroactive.
Exactly, and I do believe that they intended this statute to apply prospectively, and in fact, they didn't even wait until the date that normal laws become effective on July 1st. They had it go into effect immediately.
Well, this goes to one question or problem I have here, which is, were the 2017 amendments themselves a change in the law? I mean, has this court ever said, we will consider a once legal sentence to be illegal because of a change in the law? I don't think we've ever said that.
No, and I don't think we do, which also kind of goes back to what exactly the legislature was trying to do with this. Now, from my perspective, in viewing Ms. Chalmers' testimony, I believe that this provision to be substantive. However, I do think that there is a provision, or there is a way to interpret that change in the law provision to be procedural and simply a codification of current case law when we look
If it's just a codification of current law, then it doesn't matter whether it's procedural or, I mean, there's no retroactivity analysis to be done, right?
Yeah, and if it's, and again, as specifically as if it is an application of current law, it would just be the statutes in effect at the time of the crime control, which we ran into this issue numerous times in the Court of Appeals regarding juvenile decay of juvenile adjudications, in which that statute actually had a retroactivity provision, but these cases have been routinely struck down by the Court of Appeals because it wasn't in the statute at the time that the client was convicted, and therefore could not basically, after 2016, come back and say, hey, I need to have these cases decayed when I was convicted of my crime in 2014. That has routinely been struck down. So if that is what they mean by a change in the law, as a change in the statutory law, then I think that would simply be a codification of current case law and also not reach Mr. Newton. So it's either procedural and does not reach Mr. Newton as a codification of current law, or it's substantive and can't be applied retroactively. Either way, Mr. Newton should get relief. I see that my time is up. I would just ask this court to remand this case back to the district court for resentencing with a criminal history seat. And that is the end of my prepared remarks.
Do we have any more questions?
Just one quick one. If that happens, I see that your client got a downward departure on the Class B. If it goes back to resentence as C, is it possible your client could end up with more time?
Actually, no. The high number in the C3 box is 107 months. Okay. There's a significant jump between B and C. So,
any other questions? Thank you, counsel.
Thank you.
The state would begin with the argument that essentially we don't even need to get into the retroactivity aspect of 223504.3. From the state's perspective, this is essentially a new motion to correct an illegal sentence before this court. The first motion filed before the district court pursuant to Murdoch. The second motion to correct an illegal sentence was before the Court of Appeals with an evaluation and interpretation of Apprendi. And then the third motion to correct the illegal sentence is before this court with the argument of Wettrich. From the state's perspective, bringing this essentially the new motion to correct the illegal sentence based upon that Wettrich argument that came into effect after the application and implementation of 223504.3 bars the defendant from bringing this new collateral attack on his
Are you
sentence.
saying that he needs to reinitiate this type of attack in district court, or what needs to happen here?
I'm saying that he would be precluded from being able to do that based upon the statutory change in 223504.3.
What you're,
Because it's a change of law.
Because, go ahead.
I'm just trying to understand, you're just saying functionally, he's had 3 different 3504 motions, even though they've all been in the same case because he's shifted his argument.
That is correct, Your Honor.
but what I heard you say is this motion, the third motion that attacks Wettrich that we're talking about, was filed after May 18th, 2017 effective date, and since the amendment was already in place when he filed his motion to correct, then that amendment applies to his motion, is what you're saying.
That is correct, Your Honor. The decision from the Court of Appeals, or the statutory amendment was May of 2017. The decision from the Court of Appeals in Mr. Newton's case was July of 2017. The Wettrich argument didn't come into existence until March of 2018 after that statutory change.
So to succeed on your argument, you would also have to prevail on the question of whether or not Wettrich announced new law.
That is correct. And I guess that goes into the state's second argument, is that Wettrich is new law. When it comes down to it, Vandervoort was the order put forth by this court in 2003, and the mannerism that the courts have applied and looked at the comparability of the out-of-state convictions to the in-state convictions. It wasn't until after this decision was issued in Newton, when all these other motions to modify or to correct his illegal sentence came about, that we're before this court.
So you think Wettrich overruled Vandervoort?
Although it didn't expressly state that, yes.
Right, and it didn't. But can you articulate specifically how your argument as to why Wettrich overruled Vandervoort?
Because the rule, the law after Wettrich, is that we are to now look at out-of-state crimes with the comparability analysis that they need to be the same or more narrow.
And how is that different than what Vandervoort said?
Vandervoort was comparability where it had to be substantially similar, so that didn't go into the in-depth analysis elemental analysis that we are now required to do through Wettrich, where we actually need to look at each individual element of the out-of-state crime and the in-state crime.
So to sum up, your argument is, at the time Mr. Newton was sentenced, his sentence was legal.
That is
and
correct.
It wasn't until Wettrich that it would be considered illegal.
That is correct, and procedurally that's exactly how it happened. It wasn't until the decision came through in Murdoch that he even had the avenue to file the motion to correct an illegal sentence, and that's where things progressed as this court has progressively looked at changing that and ultimately did change the law and its application to the cases through Wettrich. And from the state's perspective, again, that is new law, therefore it's firmly within the confines of 223504 and not allowing this particular argument to be brought before the court. It's precluded at this time.
It was legal when pronounced, the law then changed, and so this statute covers it.
The statute went up.
The statute covers it.
That is correct.
Do you need the statute?
At some point in time, there needs, from the state's perspective, there needs to be a cap. If you look-
Right, but this gets to my question about what's the effect of those 2017 amendments. Do you even need that, or has the law always been that we look, in order to evaluate legality or illegality of a sentence, you look at a frozen moment in time? It's not a moving target. You have to, you pick a moment in time, and that's when you decide.
At that frozen moment in time, that was the interpretation through, and the law pursuant to Vandervoort, and it was legal at that time. Does this, from the state's perspective, since this court has changed its law, we do need that protection of the statute to allow that sentence that was legally entered in 2008 to still stand. Because the new interpretation, the new law, the new rule that must be followed now from 2018 forward is what made that sentence illegal.
In Vandervoort, which was 2003, which is after Apprendi, but wasn't it before DeCamp?
Yes, that was in 2009.
And so it really didn't take into consideration what Dickey 2 talked about, the heavy constitutional overlay, did it? Does that impact anything? If we decide that Vandervoort's just close enough for government work is good enough, would not pass constitutional muster, how does that fit into the calculus here?
Well,
If Vandervoort was unconstitutional, that no one raised that constitutional, but if in today's world it would be unconstitutional, how does that, in other words, wouldn't the change in the law have been through constitutional jurisprudence way before Wettrick?
it could have been, but it was not brought forth. This court, from the state's perspective, made it an error in its decision in Dickey 2, because that essentially was a constitutional argument that was brought through a similar motion to correct an illegal sentence, and that's not the proper form to bring forth that constitutional argument. I guess, can you, well, no, what, I'm not answering your question. What?
Well, you're saying that Wettrick changed Vandervoort, and I'm saying that there are cases that both federal and our cases that would have rendered Vandervoort arguably an unconstitutional interpretation of the non-person statute. And how does that fit into the calculus if it would have been rendered invalid by jurisprudence that occurred prior to Wettrick?
Based on speculation, because that issue was not brought before the court. That would,
In other words, Wettrick just recognized a new constitutional landscape. Is that what you're suggesting? So it wasn't really a change?
was it really a change? From
Yeah.
the state's perspective, yes, it is.
Yeah,
It's a
I-
significant change of
I
how
understand.
everything has been established in Rutherford.
Let me try again. What if DeCamp invalidated Vandervoort?
I don't know the answer to your question, sir. I apologize.
Well, then Wettrick wouldn't be the change in the law. The change in the law would have been DeCamp.
Fair enough. So again, we go back to the fact that that wasn't the issue that was brought before the court. Yeah, and that still brings the state back to the argument that it's brought many times before this court that Dickey 2 was wrongly decided.
Just a factual question. When did the underlying sentence become final in this case?
It would have been, he'd never went on directed appeal, so at that point it was a 10-day sentence.
But when was that? Just remind me when that was.
He was sentenced in
2007.
He was sentenced May 9th of 2008, so it
Thank
would have been
you.
May 19th, 2008. And so before the decamps even became an issue. I guess the other support to go for the state's argument would be somewhat of a reliance upon this court's decision in Spencer Gifts. There's somewhat of a similar situation where the court made a change in law. It declared itself a change in law. It overruled prior cases in stating that, essentially from this point forward, this is how we're dealing with speedy trial time. Although this court did not specifically state that it was overruling Vandervoort and its progeny, that's essentially what it did, because what this court did do is it set the precedent of, from this point forward, this is how we are to look at the out-of-state convictions with that very strict elemental analysis. If you go through then of comparative of how what this court did, with Spencer Gifts, is it kept the decision in place at that point for that particular defendant and then made changes from that point forward. The state doesn't argue that any decisions coming before this court now would obviously be subject to Wettrich, but this case was a finalized matter before Wettrich was decided, and the state does not feel that this is something that Wettrich should actually apply to. It was a finalized sentence and it wasn't properly before the court. Are there any further questions?
Other than questions, does that conclude your presentation?
Yes, Your Honor.
All right. Thank you, counsel.
Thank you.
May it please the court. I don't believe I have any other further remarks. I do just want to respond that the state has tried to claim that these new arguments have shifted. I would like to point out that if these arguments have shifted, one, it was a shift in response to this court's show cause, and secondly, even if this is a shifting, the state also did not file a petition for review in this case, arguing the new amendments that were passed prior to this decision coming down, and therefore Mr. Newton's argument is the only one that shifted. But again, I would just like to remind this court that in Buell and Moore, this court specifically noted that it was interpreting the provision of KSA 6811 and its ancestors, and pursuant to United States Supreme Court case law, a substantive statutory interpretation applies retrospectively, and therefore it should apply to Mr. Newton as well.
The state has argued that, as I understand it, at the time Mr. Newton's sentence became final in, I think, May of 2008 was what we decided was the date. At that moment in time, it was a legal sentence. What's your response to that?
I would think that flatly contradicts this court's statements in Buell and Moore that comparable meant identical to or narrower even before Buell and Moore, and was a part
Well,
of...
talk about Vandervoort. Was the sentence legal pursuant to Vandervoort?
I don't think so. I don't necessarily think that Vandervoort and Wettrich are necessarily an apostate, because when we still do this comparability approach, we still have to identify the most comparable Kansas crime to find out something to compare it to. What basically, the way I view this is a filter, where we start with the out-of-state crime to filter out the big chunks, felony or misdemeanor. Then we go down to Vandervoort to determine what the most comparable Kansas crime is for comparison. And then we get down to the last, finest layer of the filter, which is the identical or narrower, to determine whether or not it is indeed...
Even if identical or narrower had not been explicitly announced until later, it was still part of the law under Vandervoort?
I believe so, particularly because without this identical narrow test, there is no principled way to determine what is comparable, because something that's the closest approximation could still be 5 miles away.
That's a good argument, but how does it survive Vanderbilt's language, as I recall, that says the Kansas crime does not have to have identical elements? I think that's specifically said in Vandervoort.
And it's true, and even under Wettrich, the elements don't have to be identical. They have to be identical or narrower. So therefore, basically there has to be a universe in which every instance of the out-of-state crime could fit within a Kansas crime. And so they don't have to be identical. The Kansas crime could be broader, but it would still be comparable under Wettrich, because even though they're different.
none of these arguments were made at sentencing regarding the original sentencing in May of 2008 regarding comparability, and no, the California robbery statute doesn't fit.
No, Your Honor. But at the same time, this court has previously held via Dickey 2 that these types of arguments can be raised for the first time on appeal because an illegal sentence can be corrected at any time.
Do we have any further questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. The court will take this matter under advisement.